about me. I've been practicing for almost 10 years at this point, and I've been with Tully Rinckey for almost 2 years, primarily focused in the area of family law, divorce, custody, child support, but also, helping people potentially, avoid that conflict or chart their path here with prenuptial agreements. So, Taylor, we can go to the next slide. And so we're here today to talk about prenuptial agreements. We've been seeing, an uptick in interest in this area, and people might be wondering, what exactly is a prenuptial agreement? People might be thinking of ultra high net worth individuals who need that ironclad prenup to protect them, but it is more than that. So looking here, I think at the statute is a good place to start. In New York, I think, different states are going to have different rules about what you can or can't do in terms of making an agreement. And in New York, it is, in the body of the law, it's actually not called a prenup. We have here some of the language just to read it here. It's an agreement by the parties made before or during the marriage, right? So a prenup, the prefix pre is before, that's what we're focusing on today, but you could also make an agreement during the marriage. That would be a postnup. You don't necessarily have to get to the end of your marriage to make such an agreement. We're not diving into that topic today, but so an agreement before the marriage will be valid and enforceable in a matrimonial action. That's telling us a few things, right? An agreement is only enforceable after you get married and at the, in a matrimonial action, a divorce. The agreement needs to be in writing, subscribed by the parties, that's just signed, and acknowledged or proven in the manner required to entitle a deed to be recorded. That is just, there's some specific language and acknowledgement that the notary signs in addition to just putting their stamp on the agreement. There's an acknowledgement section that must be included in every marital agreement, including prenups. The agreement may include 4 different areas, potential issues in your union. You may contract to make a testamentary provision of any kind. That's, testamentary provision is, akin to trust and states a will, and you may include in the prenup a waiver of any right to elect against the provisions of a will. What does that mean? There are certain rights afforded to spouses in the event of the death of their spouse. And, there's sort of a general idea that you can't cut a spouse out of your inheritance or your estate by will. And, with a prenup, though, you may include a waiver of such a right to elect against the provisions of a will. You may also, most commonly, I think, in prenups is to include provisions for the ownership, division, or distribution of separate and marital property. So I think very often, people are thinking of protecting what they have as they enter a marriage. And actually, in the law, there is provision, even if you don't have a prenup in place, your premarital property, if you, maintain it as such, is going to be your separate property, assuming, you don't commingle it with joint assets or change the character of that property after you get married. Even without a prenup, that your separate property premarital may continue to be your separate property. However, you may put additional clarity in the prenuptial agreement about your separate property and also future marital property, stuff you may not even have yet. You can go deviate from the default, position of New York state law, dividing marital property, what is or isn't marital, and chart your own course there in the prenup. You can also provide for how maintenance or old-fashioned term is alimony, spousal maintenance, spousal support. In New York since 2015, it's been according to a formula, and you may have include in there, alternative provisions for how you might go about, whether or not the maintenance will apply to your case. Of course, with respect to maintenance, the terms need to be fair and reasonable at the time you make the agreement and not unconscionable at the time of entry of final judgment. That's the divorce. Unconscionable meaning that, it's so unfair that it might shock the conscience of your common sense. The fourth area is also provision for the care, custody, care, education, and maintenance of any child of the parties. Usually, I think, people planning to get married, more often than not, they don't already have kids. We generally don't, include such a provision in prenups providing for custody or child support. And you can't, in a prenup, you cannot provide for future children. They don't exist. That's not an enforceable or valid item to include in a prenup. And just wrapping up this slide, I have, the selection of law in New York State. We're drafting the contract in New York. Included in the prenup would be, that we're selecting New York State to be the law of the prenup. It's going to be interpreted according to New York law. And again, just touching on, a prenup is only enforceable if you get married. If you sign a prenup and you don't get married, that's not an enforceable contract. That's a prerequisite. As well as we talked about, the prenup becomes enforceable in the context of a divorce action. All right, Taylor, we can go to the next slide. And then, so now we have a little bit of an idea about what a prenup is, who might use one, who might get one, be thinking about drafting one. Really, it's not just the ultra high net worth people who should consider it. I think, most often we see people saying, hey, a prenup is a good idea when they are entering into their second marriage. So that they had their first marriage. Obviously, if you're getting remarried, that means your prior marriage is over, and you may have gone through the divorce process. Maybe it was amicable by agreement, maybe it was not so amicable, and you had, court appearances, and you went through that whole process, and you're now looking to maybe get ahead of some of the potential future issues, and then that second marriage, from the first marriage, or even if you weren't married, you may be coming into this marriage with children from a prior relationship, and that is also going to affect the calculus. You may have a spousal support obligation that's ongoing for a period of time. You may have a child support obligation that may be going on for a significant period of time. In New York, child support runs until age 21. So if you have young children and you're getting remarried, you may be looking at, having that long-term obligation that's going to be income that you'll be providing to these children from another relationship that you are now not providing to this marriage. And in the prenup, you may try to address that in some fashion. And inheritance as well. The children from a prior marriage probably are going to be included in some way in the will, be a part of your inheritance, and you and your future spouse may think to put something in a prenup addressing that, how the each spouse is going to be provided for. You may also consider using a prenup if you have significant assets, and existing family business is a particular form of that significant asset. There are intricacies involved in a family business, and you may also be looking to keep that separate and ensure that in no fashion is the fact of your marriage going to allow for some piece of that family business to become part of the marital estate. it would be important to have a prenup in that case, as you couldn't, in the event of a divorce, come up with some fairly creative arguments for how and why that family business might have become marital or, in some way. And I guess with that, I'll turn it over to Bob for the next couple slides.
Okay, I'm trying to start my video. All right, very good. So we're on the third slide, and we want to talk about what a prenup actually can do. And I will tell you, I've seen a lot more prenups in the last 5 years or so than I've seen in my 35 years of practice. And we want to think about a prenup almost like autopsying a divorce. This is why you want to work with an attorney who knows divorce very well, because only by seeing how things go bad can we help people prepare to prevent that with a prenup. So it's almost like pulling it apart and reconstructing it. So I'm going to talk a little bit and give some concrete examples of what the laws of equitable distribution support are in New York, so that you can get a handle on what the law would do to you if you didn't have a prenup. And that then creates the avenues for what do you want to do. Essentially, with a prenup, you are circumventing what the law says, and you are deciding how you want things done should the marriage fall apart. And understand these are not very romantic documents. They can be very difficult to discuss. And oftentimes having attorneys who know the sensitivity of the situation can really help that dialogue. All right, so briefly, equitable distribution. New York State basically says we think of marriage like a timeline. It has a beginning point and an ending point. Once the marriage is solemnized, officially done, then the clock starts running on what are marital assets. It does not matter if it is in your name or your spouse's name. Anything acquired on the marital timeline from date of marriage until the date either somebody files a divorce action or a legal separation agreement is signed, everything on that timeline is marital, with a few minor exceptions like inheritances from third parties, personal injury recovery. You get hit by a car, break a leg, collect some money, or gifts from third parties. Your Uncle Louis gives you a Mercedes. Provided that those items are kept separately in your name, they do not become marital assets. They keep that separate property characteristic. So as Mike was saying, we have a lot of people getting married a second time. Unlike back in the day when couples married in their early 20s or mid 20s, they came into marriages with a used car, student debt, and not much else. These days, people are coming into second marriages, or they're waiting longer to get married. I have many people getting married who already have ongoing business interests, family businesses, children from a prior marriage or relationship, retirement assets that they've been contributing to for 10 or 20 years. So we have to address, how do we deal with those assets if they grow during the marriage? If we shade the character of them and decide to put our spouse's name on our inheritance account, put our spouse's name on our premarital investment accounts, how does that affect it? So understanding that equitable distribution timeline is very important. So we've talked a little bit about separate property. It's what you had before you married, or it's one of those three categories of inheritance, gift, or injury settlement. Everything else, marital, keeping it in separate name in and of itself does not make it separate property if you got it during the marriage. Let's talk about some practical examples before we get into the other items on this slide. Your family owns a business and you have 10 shares in it at the time you marry, and then during the marriage, you are gifted or purchase or acquire more shares in the business. Some people want to keep the entire business forever separate property. Even if I go from 10 shares to 50 shares by the time I divorce, we want to keep all those shares separate. Why? It's a family business. If there is a divorce, the business is going to have to be evaluated. Shares may have to be bought out. It can decimate a family business. Also, coming into a second marriage or a relationship where there are prior children, I need to be taking care of putting my children through college somewhere down the road. And I started a 529 account. Now that I'm married, I'm putting more money in that 529 account. Well, technically, that money is marital money. Maybe we want to talk about keeping that 529 account and whatever I contribute to it during the marriage as non-marital or separate property. Just some practical examples. There are also people that marry after very short relationships and are a little bit skeptical about, well, I make all the income, my spouse doesn't. I don't want to find myself divorced after 6 years and having to pay spousal support. So perhaps you want to put something in there about waiving spousal support or limiting it. For example, as Mike said, we can address spousal support in the prenup as long as the court doesn't find it unconscionable at the time of divorce. We can say, look, we have to be married at least 5 years before your right to spousal support will come into being. We can do that. Or we want to say that regardless of a divorce, there will never be spousal support. I won't pay you, you won't pay me. Again, that could be reviewed by a court if they find it's going to leave somebody destitute. But for the most part, you have an enforceable term there. Spousal support these days, maintenance, what as Mike said used to be called alimony, is now governed by a mathematical formula, much like child support back in 1989 when they passed the formula. In 2015, thereabouts, they came up with a temporary and then a post-divorce formula. So it's math. It doesn't really discriminate. If you make this much and your spouse makes that much, it goes into the calculations and the number spits out. You can deviate from that. You can create your own schedule of support. I recently did a prenup where my client had some significant business interests, and we actually put in a graduated scale. If they're married X years, this is how much of the business interest she gets. If they're married 2 times X years, this is what she gets. And then we even capped it at an ultimate amount so that my client's businesses wouldn't be decimated, and yet his spouse would be compensated for the fact that a marriage is, under New York state law, a financial partnership. The laws of inheritance. Here, Mike touched on it. New York State also has statutes, the EPTL, estate and trust law, that says that if you die without a will and you're married, your spouse has priority in inheritance. Well, similarly to a prenup, a will allows you to circumvent the inheritance laws and decide who you want to leave your money to. There are certainly limitations in terms of cutting your spouse out of a will. But if you have a prenuptial agreement that says we are waiving that right, we don't want to inherit from each other. I've got a pre-existing family, my spouse has a pre-existing family, and we want their kids and my kids to be able to inherit everything. If one of us dies, we can put that in the prenup. And that will be binding in the event of death, even if it is contrary to the estate trust and powers laws. So all of that can be done. How can the agreement deviate from these laws? Basically, any way I've just mentioned. Retirement is a big one. Somebody has worked for 20 years and acquired a pension or a very significant 401k. At the day they marry, all future contributions to that retirement of 401k is marital property. So if I had 100,000 in my 401k when I married, and when I divorced, there's 250,000, then arguably 150,000 of that is marital property to be divided. Maybe I want to keep that. I don't want that extra portion to be marital property. If we both agree in a prenup, we can waive that automatic right under the domestic relations law. And another one that is big is real estate. Many people, again, because they marry later or their second marriages, come into relationships owning real estate. What happens to that house? Is that house automatically going to become marital property when we marry? Not unless I put my spouse's name on the deed. But the law will still presume that if that house goes up in value because I've been paying the mortgage down, I've been making improvements, my spouse has been putting the paycheck into the joint account and helping pay for maintenance and improvements and helping pay down the mortgage, my spouse now has a claim to an interest in that home. Maybe not a full 50% of the equity, but an interest. It becomes a nightmare for the litigants. It becomes wonderful for lawyers because it puts us to work. But if we can clean that up for you and prevent that going forward and settle things in advance, that is better for you in the long run. So how can the agreement deviate from these laws? Basically, any way that you want to recharacterize or treat your assets, whether they're premarital or whether you acquire them during the marriage. If you could go to the next slide, Taylor. What can't a prenuptial agreement do? And I'm going to move through this one a bit quicker because there may be questions and answers at the end, given how intricate some of this can be. What can a prenup do? A prenuptial cannot waive child support obligations. That's because the child support is for the child or children of the marriage. So you can't say, well, if we ever have kids, I'll never pay you support, you'll never pay me support. It cannot guarantee a child support sum, nor, and I didn't add this, but I should have, it's pretty important, nor can it guarantee custody. If someone writes into agreement, if we have children, we want, and we ever separated, divorce, we want dad to be the primary custodial parent. You could put it in there. It's not going to be guaranteed enforceable. Matter of fact, it's not even binding on the courts at all. Because what if dad, God forbid, is an alcoholic? What if dad has been arrested for something, not something you wouldn't want a person watching your children, or mom for that matter? So, it's called precatory language, meaning it may be wishful language, but it's not binding on the courts. So, children, even if you have children with the person you're marrying before you marry them, and many people have children together and then get married, you still can't guarantee that custodial arrangement or the child support sum. You cannot sunset the marriage. What that means is you cannot agree that at a certain date you will divorce. I know it sounds very bizarre, but I've been asked this question. Similar to, your driver's license expires after a few years if you don't renew it. That's not the case with a marriage license. And you cannot build that into the agreement and say, we agree that we will divorce after X years. Spousal support can be waived, as we said, but it will be subject to court scrutiny and potentially being set aside if I said I will not pay my spouse any spousal support, but at the time of our separation or divorce, my spouse is physically disabled, can't work, maybe legally blind, can't support themselves. Obviously, the courts don't want people becoming wards of the state. And you cannot agree to do anything illegal. I know that sounds pretty basic, but you can't agree to do something tax-wise that may prove to be illegal. You can't agree to perhaps secrete assets or anything that may be found to be illegal. But I haven't had anyone ask me to put anything potentially illegal in an agreement. Just be aware that illegal doesn't just mean criminal. It could also mean something that would subvert the tax laws. Okay, we can go to the next slide and pass it back to Mike.
Okay, and then this kind of goes along with what Bob was saying about you're considering what all to include, what can or can't be in the agreement, but there are some things that sort of must, maybe is a strong word, but really should be in every agreement, and that's building disclosure of assets and debts into the agreement itself. That way there can be no question that disclosure occurred. Full disclosure is available to parties in a divorce, and you think in good faith and fair dealing, there should be at least disclosure of all the substantially important, substantially valuable assets. Assets should be listed in the agreement specifically, going line by line in the agreement through the checking accounts, the investment accounts, the cars, retirement, any business interests, etc. And attached approximate values. It doesn't have to be to the penny. You don't have to attach, your most recent bank statement, but you're putting the approximate values in there so that anyone on review of this agreement is, seeing that the disclosure was there. And, the only time that you're really talking about this agreement after you enter into it is when it is being reviewed and potentially scrutinized by court, because you'll be getting divorced and you may not be in as happy a place at that point, and you may have one spouse looking to set aside parts of this agreement. So to build the enforceability into the agreement, you disclose and set it forth explicitly in the terms of the prenup. Real estate, Barb mentioned, real estates can be complicated. Maybe you have separate property real estate coming in, and you're looking to say that's going to stay mine, but you may also be looking at potentially building the marital estate. And what happens if you do buy a property and it's the marital home and you're in it for years or decades, and now you're thinking about how is it going to play out when we get divorced? Are we going to give each other the opportunity to have one or both of us buy the other out? How are we going to value the property? How are we going to even choose the real estate broker? It's nice, when you're about to get married, you're both sort of like-minded, looking to, you're in a happy place, and you're probably feeling very cooperative. And at the time of the potential demise of your marriage and you're looking at divorce, you're in not such a friendly, cooperative space. And even you might be surprised, but even the selection of a real estate agent could be a contentious issue. So you build in sort of maybe like a lottery system. You pick, husband picks two, wife picks two, you put it in a hot hat, draw it by lot, kind of thing. But you can put all of that into an agreement, just mechanically how you're going to conduct yourselves in dividing your property. Jumping down to business interests, that can also be fairly complicated. How you're going to do that, again, how it's going to be valued, how you're going to determine percentage shares. As Barb mentioned, maybe one person has the closely held business or is planning to start a business during the marriage, in which case are you saying now it's very clearly marital under the laws of New York equitable distribution, but the non-titled spouse, or the spouse who maybe doesn't have percentage interest according to the corporate documents, does that spouse have an increasing claim to the share of the business as the marriage endures? Retirement, it could be as simple as a complete waiver, but retirement is usually the most significant, maybe the second most compared to real estate, but their most significant asset. And they cannot be joint, right? You can't have a joint retirement account. You can't have a joint 401k if it's through your employment. It's clearly going to be in your name alone. But how are you going to divide that up? Is it going to be something less than 50-50? And then if you are going to divide it and not waive it, there's different plans, and each plan is unique. You need separate court orders to divide retirement accounts. There's different rules pertaining to qualified versus non-qualified plans. Is it a pension versus a 401k? Is it a public pension versus a private pension? And then even state versus federal versus military. These all have different rules. There's a different set of benefits, pre-retirement, death benefits, joint survivor annuities, spousal, former spouse benefits. And you can get into the real nitty-gritty about that, and it is important to do. to make sure that the division is then properly done in the future. And we can go to the next slide, Taylor. Okay, so this role of counsel, it's really also, the validity of the agreement and your potential ability to set it aside. Always parties are encouraged, advised, recommended, short of forced or coerced, to have attorneys representing them in at the negotiation, preparation, at least review of these agreements. It is highly advisable, but it's not necessary. The reason it's highly advisable is because you are an adult free to contract, and once you do execute an agreement like this, it is almost certainly going to be binding on you after the fact. So, you're advised to get the attorney beforehand because it is such an important document with these potential consequences, not because if you don't get one, it'll be invalid. It's actually the opposite, right? So you want to have the attorney so that you make sure that you are doing the right thing and you understand your rights as you're entering into this agreement. One attorney cannot represent both parties. You could have a situation where one attorney represents one party and the other side is unrepresented. That's still a valid course of entering into an agreement, but one attorney can't represent both parties. If you are thinking about setting aside a marital agreement, it is a very difficult thing to do. The seminal case in New York Court of Appeals is Christian v. Christian, and in that case, the parties entered into a separation agreement. It was back before we had no fault rules, 1977 case, very old. But they entered into separation agreement. The wife filed for divorce, alleging the fault ground of cruel and inhuman treatment. The husband counterclaimed, saying, we've been living separate and apart for at least a year and abiding by the terms of a separation agreement that we entered into, and asking the court to incorporate, but not merge, the separation agreement into the final divorce decree. The wife then sought to have the agreement thrown out on the basis that it was fraudulent, there was misrepresentation, concealment, she was coerced, it violated public policy. In the agreement, I think they said that the parties will equalize their investment accounts. Husband had a $200,000 investment account, wife had an $800,000 investment account, and so she didn't like the deal she got, and sought to challenge it. But I'll just note, the language of the court on review, they stated that judicial review is to be exercised circumspectly, sparingly, and with a persisting view to the encouragement of parties settling their own differences in connection with the negotiation of property settlement provisions. When there has been full disclosure between the parties and an absence of inequitable conduct or other infirmity which might vitiate the execution of the agreement, court should not intrude so as to redesign the bargain arrived at by the parties. And so, that sort of touches on the bullet points. If you are looking to set aside the agreement, it's a high burden of proof, and you have to show something in the order of fraud, duress, fundamental unfairness. That goes back to the unconscionability term we were throwing around earlier. It's so unfair as to shock the conscience of a common person. And then, mental incompetence is a possibility. Obviously, if you are not of sound mind to enter into a contract, then it could not be valid at the time you entered into it. But it is a high burden of proof. Courts are not inclined to set these agreements aside. So that sort of flows back to the idea that you really should have an attorney to protect you in the first instance, because once you sign it, there's not much hope of going back. And then I'll turn it over to Barb for the next slide.
Thank you. And I just want to tap a little bit into what Mike just said, because I have had litigation where attempts have been made to set agreements aside. And while it is very difficult, it's not impossible. And simply having to go through that extra layer of litigation is often difficult and often puts people in a place where, they relinquish something they shouldn't have to because there's the time and expense of litigation that they may very well win, but they could lose a little bit on. A few other tips on this: mental incompetency. That doesn't mean you're in therapy or you're taking Xanax when you get anxious. Mental incompetency has a certain level of necessity that has to be proven to a court that you were basically. I had a client who actually suffered a psychotic break at the time that she signed the agreement, and so it really has to be something significant like that. And also be cautious if you're also arguing over custody. Do you want to be telling the court that you suffer from a mental incompetency? And while fundamental unfairness itself, as Mike said, if it shocks the court's conscience, can set an agreement aside, there's actually two layers here. If you can't prove that the agreement is so fundamentally unfair, but you can prove that there was fraud in entering it. My spouse told me he didn't have a pension, and I find out he actually had one. Even if you can prove fraud or duress or mental incompetence, if the agreement itself is still considered to be fundamentally fair by a judge, then they're not going to set it aside. So there are different layers of this, and we're emphasizing that because these agreements should not be entered into casually without realizing that down the road, just brushing something under the rug and not worrying about it today doesn't mean it won't crop up tomorrow. Okay, now I want to hit on the retirement addendum. This is very important, and I am surprised that I have seen many prenups done by other attorneys that failed to do this, and this is a big, big problem. As Mike said at the first slide, the agreement that you enter into is entered into before the actual legal marriage ceremony, not after. It's a prenuptial. It precedes the wedding, the marriage. So it must be signed, even if it's signed the day before, even if it's signed the day of, although we absolutely don't like that happening because that could also cause it to be scrutinized a bit too closely. My spouse gave it to me an hour before the wedding while I was, putting my dress on. But it has to be signed before the marriage. Assuming it's signed before the marriage, if the agreement contains any waiver of retirement rights at all, any waiver, even if you're not waiving the marital portion, but perhaps you're waiving a survivor annuity or a pre-death benefit, if it contains any waiver of rights at all to retirement interests, you must, following the wedding, and it doesn't have to be the same day, you can wait till you get back from your honeymoon, but within 30 days of the marriage or somewhere within that time period, the two of you need to come back together and sign an addendum to the prenuptial agreement that confirms the waiver of retirement rights. The reason is this: some of you may know, if you have a 401k or a pension, retirement plans are governed by federal tax law, what we call the ERISA statute. And federal law, as you remember from your civics class, trumps state law. So if state law says something and it doesn't match federal law, you're going to have a problem. Since retirement accounts, because they're pre-tax, are governed by federal tax law, a party cannot waive an interest in one of these pensions or retirement accounts until they are actually spouses. They're actually related and married to each other. So again, just to reiterate, if in your prenuptial agreement there is any waiver of any rights related to retirement accounts, your attorney must present you with an addendum to sign after the marriage ceremony. And what we do is we include a clause in the prenup that binds the people to sign the addendum after the marriage. So someone doesn't just say, oh, I know I said I'd sign it, but I'm not going to. So that is very important. Timing of execution of the addendum, as I just said, should be done post-marriage, does not have to be done immediately. In the agreements, we usually say you'll sign them within 30 days. If 30 days go by and you don't sign it for 60 or 90 days, I had a client whose father passed away right after the wedding and they didn't get around to signing it for several months. That's okay. Just don't forget that has to be done, and don't let your lawyer forget that has to be done because that is very important. And it will help you also when you go to make your elections as to who's the beneficiary on my 401k. Many jobs will not allow you to name anyone other than your spouse unless that spouse executes a waiver. So this will help for that as well. Okay, so we can go to the last slide, and then we'll save time for question and answers. Execution requirements, signing of the document. We bring this up because Mike and I are bringing up points that we have seen become issues for people. Proper signing is key. If you're going to go online and think you're going to create your own prenuptial and just sign it, be aware you can run into trouble. The New York state law says execution must be akin to what it takes to execute a deed, meaning there has to be not just a notary, but an appropriate verification on the document and signed by both parties. We also, in most counties, will also record an original of this prenuptial with the county clerk. Some counties don't take them for recording, but most of them do. Same reason you record a deed. If the copies get lost or burnt in a fire or something, the original exists somewhere where it can be always obtained. This Matisoff v. Dobie case was from the Court of Appeals, like the Christian case that Mike mentioned. And we learned the hard, or at least this couple learned the hard way, that having not put the proper they signed and notarized the agreement, but it wasn't duly verified. And come time for their divorce, one of the spouses presented the prenup to the court, and the court would not enforce it. Even though they both admitted it was the prenup, they both had attorneys, they both signed it, they were both notarized, it lacked this verification. Court kicked it out. Hard lesson to learn. Out of state, we have clients where maybe our client is in state, the other is out of state, or at the time they're signing, they're out of state. If the document is being signed out of state, it must bear an out of state notary. There is an equivalent notary that is good in New York State, but if you're signing in Colorado, you cannot use a New York State notary. It has to have the due verification and notarization for an out of state notary. Again, your attorney should know that, but we have seen documents that don't have the proper execution, and they're not worth the paper they're written on. Similarly, signing outside the country. I have clients that are signing out, one party is outside the country. I had a client whose spouse was in India and was going to be traveling to the United States for the wedding, but would sign the prenup in India. Make sure that your attorney has confirmed all of the out of country signing requirements. Documents can be signed out of the country, but again, must bear the appropriate verification. It's up to your attorney to know this, but again, it helps for you to know it. It's up to our doctors to know a lot of stuff that, we're always shocked our doctors don't know. And then I'll turn over to question and answers, but Mike mentioned something I just want to touch on briefly. We talked about real estate, and if someone comes into a marriage with a house, or even if a house is bought during a marriage, you can also include a clause that talks about if there is a separation or divorce, who has the first refusal to buy the house from the other party, or if there's going to be children, which party has the right of a first refusal to stay in the house, and if they have custody, whichever party ends up with custody, will that party have the right of first refusal to stay in the house? Stability reasons for children. But I think the bottom line here is we can do magic with these. It's up to what you want to accomplish and what both parties are comfortable with. They are, again, not the most romantic things to do. You want to be picking out flowers and planning, bachelor parties or whatever. I would say let the lawyers be the bad guys. These are not romantic things to talk about. I tell my clients, you can always say, look, this is something I didn't think of, but my lawyer brought it up. And my lawyer cautioned I should think about this, and make the lawyers the bad guys. We're used to that. Bottom line, we're here to help you. Okay, we'll turn it over for question and answer.
If anybody has any questions for Barbara or Mike, please send them over in the chat and I will send them over to our presenters. But in the meantime, I will send over some questions that we have received.
Okay, I'll take the first one, Mike. I didn't read the second one, but I read the first one. I'll take that. They are enforced. Yes. Well, let's put it this way. I cannot account for the law of other countries. We can only account for the law of the state of New York and how they're looked at here. I will tell you that these are enforceable pretty much within all 50 states. I think Mike mentioned earlier, we have an election of law. When you sign a prenup, we put in that it will be interpreted under the laws of the state of New York, because attorneys don't know the laws of all 50 states, more or less all countries. We are barred state to state. So because we only know the laws of the state of New York and the couple live in New York, at least at the time of the marriage, we apply New York state law. Therefore, if the couple later moves to California and they get divorced, California will have to apply New York state law. Will other countries have to do that? That is up to the laws of the other countries. If you anticipate that you might be living in another country, you can do that. But certainly you can always come back to New York and enforce it in New York. Mike, I didn't see the second question, but I'll let you take it.
Yeah, it's how do I protect my assets when my spouse has children from previous marriage? So I assume that the assets are, if you're thinking about it, it's your future spouse. I mean, you could do a post-nup, like I said, that's not really the subject of today, but you could, to protect your assets, you would disclose them in the prenup, lay them out, and set forth how you want to maintain them as your separate property. And then you can be specific about the terms of what you must do in order to keep your separate property, or what you might do that would then transform it into joint property. Or you'd have to take some sort of affirmative steps. But your spouse's children from a previous marriage would not necessarily, they wouldn't have any claim to your assets that are in your name.
I believe those were our two questions, the questions that we had for today.
Okay, if there is nothing else, our contact information is listed there, and feel free to share it with anyone who might be dealing with these issues. We did not, we originally had thought about doing a postnuptial and prenuptial presentation, but it could get kind of convoluted and problematic. But Mike did briefly mention postnuptials, and I'll let you know that those are agreements for couples that aren't ready to legally separate or divorce, but have found that they got married and either there were things they should have done in a prenup and didn't do, or issues have arisen during the marriage that causes them to want to settle some of their property and financial rights short of actually separating and divorcing. And those are called postnuptials. There's a lot of reasons to use them. I've seen them used in instances where there's been some infidelity in the marriage, but the couple wants the marriage to work and they want to stay together. So they may address, it caused anxiety over maybe the house. So they wanted to address just the house, or they wanted to address a lot of things. Those are agreements that are available, and we're certainly able to advise and help with those as well.